Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican police service.
Is that correct?
I didn't ask you to interrupt me.
Welcome back to... Hello, can you hear me now? Welcome back to the Court of Public Opinion. I am the Recovery Addict. We're back again this morning because, oh my goodness, I thought we'd get a little afternoon off. I thought we'd get a little time off. Maybe a little nice peace and quiet. Nope. Courts had other ideas. And when it goes crazy, did I say this morning? It's this afternoon. Sorry. It's morning somewhere. It's definitely afternoon here.
I'd agree that everything you just said is one of the most horrible things I've ever heard.
All right. It's afternoon. Oh my goodness. Court's happening. Do you guys want to sit down now? I thought we'd just be quick and stand through the duration, but I guess maybe not. Okay, I'll turn on the chairs just for you guys. All right, chairs are turned on. I have to say this before we go too far. Greeners, you're slacking. When the Steve breaks, first in chat today. When the Steve breaks, congratulations. First in chat, as you know from watching Greeners, get sentenced with
break for lunch,
with internet ownership and.
The zombie apocalypse may be upon us.
Yes, it may be upon us. It may be. Today is crazy. This is absolutely nuts. We've got a little bit to watch here in a court where we're seeing things we've never seen before. I've never seen before. And I'm going to share all of that with you. For those that are watching, I loaded or curious, I loaded the full video, the clean video from the Owens v. Eckerd live stream this morning. It's now up on Top Mark Media. It's not a live stream. It's uploaded as a video. It's just standalone, no commentary. It's completely clean as far as overlays and images and everything go that way. It's straight from the Pool Media feed. And so that's available now. I have tagged it as over 18 just because I think technically it's like over 16, right? But it only gave me the over 18 option. And so you're going to want to just be mindful. If you got kids in the room, it's talking about how paternity happens or didn't happen in this case, as the case may be, depending on which side you're on. All right, so that's up over there. It's probably hidden. You have to search for it a little bit, but either way. All right, that's not what we're going to do. By the way, when the Steve breaks, congratulations. Internet ownership, all yours for the rest of the day. If you want a commemorative certificate celebrating your win, just go to the shopping page on our YouTube page, and that tab, you can search and find the certificate of internet ownership, which you can download and fill in the blank with your name. It's already pre-signed by yours truly, and I recommend using it as a cover sheet for resumes. There you go. All right, so thank you very much for taking care of that. Now, hang on. We were gonna watch Wade Wilson. We are. Wade Wilson is coming up. It's in our future. Not necessarily today. Okay, we're going to try to catch up. Let's see. Did you see that Sarah Boone finally got a date for trial? I'm looking at Sarah Boone's live stream right now. We're waiting for her last letter to be posted. It's not posted yet. 58 pages long to the judge. We'll bring that to you as soon as that drops. But right now, Sarah Boone's new hearing is 10/7 of 2024. That's the trial date. There'll be a hearing at 9/24 of 2024. Trial management conference immediately before that, a week before or so. And there we go. So we'll keep an eye out for that letter, which should drop probably this week, as the Florida courts in Orange County take about 3-4 days usually to get things scanned and in the docket. But that's not why we're here. That's not why we're here. We're here because of, get ready, buckle up, Young Thug. The Young Thug trial. This is Georgia v. Jeffrey Williams. Young Thug, you know the trial. It's on day infinity right now. It's been going for most of our lifetimes. It seems that way, and it will probably go for most of our children's lifetimes, the way things are going. But let me just bring this in. There was one other time I tried to share with you the Young Thug trial, and I think about 10 minutes in, somebody Zoom bombed the court Zoom feed, which was on camera, with somebody doing the hula sans clothing or something similar like that. I don't know. It was terrible. We had to bail immediately. I deleted it. We have not been back since then. We're going back today, just briefly, because, oh my goodness. Yeah. Let me give you the lowdown. Okay. First of all, this is a RICO case. It's like organized crime is what they're alleging. It's a gang involvement, organized crime. We have like 7,000 defendants, and all of them have 1 or 2 lawyers. So the entire courtroom is just defendants and lawyers everywhere. It is the worst possible setup for progress. Okay. It looks like Congress. I'm sorry, Pickles, not politics, but every time there's a problem, every single lawyer wants to object and stand up and say, "Hey, me too. I also have a complaint for my client." You know, it is bizarre. It's crazy. It makes your head hurt for the legal system. Today, one of the defendants' lawyers basically said to the judge, "Judge, we just heard that you had a meeting with a sworn witness in your chambers without us there. And we want to know just what's up, and we ask for a mistrial and everything else." And the judge is livid, and he's like, "You wouldn't have known unless somebody broke the rules. How did you find out?" Okay, he's not saying what it is. Okay, he's saying, "How did you find out?" And he's saying, I don't have to tell you, attorney-client privilege. I don't have to say anything. And the judge is like, "Well, I'm telling you to tell me." And it goes off the rails. It goes off the rails. Someone is ending up in jail. Okay, I teased that on the thumbnail. That's not that's how it goes down. So here we go. We're gonna jump in. Oops. Let's go over here. That would be better. There's the judge. Buckle up.
All right, do we have everybody with you?
Everyone that matters is here.
Sergeant Ingram?
Yes, sir. Everybody's present.
Okay, Mr. Steele, would you take the podium, please, sir?
Mr. Steele's the lawyer for his client. It's a 2-man team defending his client. Mr. Steele's going to make an argument here to the judge about where he stands. Look at this. These are all. That's not the gallery. Those are other defendants and their lawyers.
All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again. And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6. I know what the rule says, but here's the thing. Well, let me just. You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand. I don't want to be held in contempt. And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened. Sir, that's a whole separate issue. And that's why ex parte conversations are recorded. Why would it be ex parte?
You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you who
told?
How did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you.
You're saying,
you're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sub and substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point.
I can tell you where you'll be.
No, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not sure.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor,
and if that person gave you that information, or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been. Well,
it's because she has a client she's supposed to represent.
Who are you talking about?
But anyways, I'm not going to have a.
What I got this information.
I'm not going to have any further conversation with you about this. I want to know. The question still remains. I want to know who gave you the information.
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And whenever, yes, I have an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue
what are you doing here?
that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can. That's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this. So
that's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele. That is not when That is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read it, I'm assuming you read it. That's what it says. And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
And you can't hide behind, yeah, but the thing is, I think you got this information, somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we entitled to
that leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
you've already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, ma'am.
We're not waiving
Ms.
anything.
Love?
Steele, take your papers and put your hands behind
Your
your
Honor,
back. Oh, he's not done.
And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Love.
Okay, excuse me.
Okay. All right.
Wow. We're not letting her tell us what happened.
Your Honor,
we don't accept that as fact. I don't trust her.
Disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants. We cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them.
So hold on just for a second. Let me tell you what's happening. So defense is saying, hey, you guys did something you shouldn't have, and we need to know what it was that you talked about. And the state and the judge are saying, hey, you found out about something you shouldn't have because you weren't part of that, and we need to know how you found out. And so they're arguing back and forth about this. See, Amber says, context, Kenneth Copeland called with an immunity deal and pled the fifth. He was held in contempt and sent to jail. Yes, that was earlier. Court was delayed 2 hours this morning because of the ex parte hearing with the judge, state, and witness. Anyway, so these two sides are fighting. The judge wants to know who's the rat, okay? Who told what we did? And the other guy's saying, hey, what you did was against the rules, and we need to know what happened in it. And they won't give an inch for each other. They're absolutely just
two counsels for the defendant.
Stubborn as
we did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask
threatens the state bar
what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that,
what does that mean?
Would appear to call for being addressed in some other way.
They're
so
saying
as to
behavior by the
Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
She says, objection, non-responsive, move to strike everything the other attorney said when he didn't answer your question, Your Honor.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's
attorney-client privilege
answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Careful, you move your feet, you lose your seat. Let's see who else wants to talk here, because
regarding,
she's not done. Hang on, and this isn't over.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right.
Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
the court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right,
and frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay.
Judge doesn't ask him where he got the information. Now everyone else gets to stand up and.
What is it, Mr. Sharp?
And say me too.
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40.
He was late.
We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things.
Bingo on the willy-nilly.
So, I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript, and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations. But I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor.
That's a good soundbite.
I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied.
It's denied.
Okay, I'll use the same thing. You want the Harvey? Okay, all right. Okay,
Same thing for
Mr.
you. Yeah.
All right.
Okay, you as well. All the lawyers like us, too.
Okay.
We are also adopting all the arguments that have been made by
All right, sir.
Steele, by Attorney Keith Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also we were here.
Is the attorney's last name Shart?
And when the court did come out, we were not made aware that there had even been an explanation.
Good grief, Your Honor.
That was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court we believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe it's appropriate.
Everybody wants a mistrial, except for the
All
state.
right, motion for mistrial denied.
Denied.
Ms. D. Williams?
Mr. Williams.
All right, thank you,
They
madam.
adopt as well.
Motion's denied. Mr. Garner?
He's saying us too.
Okay, so noted.
These
All
are
right.
defense. They have to sit all the way in the
Okay.
gallery. There are so many
Mr.
defendants.
Steele, last time. Who told you?
Mr. Steele.
All right, Mr. Steele's in custody.
He's in custody.
Once he's clears
Lock
the
him up.
area, we'll go ahead and get started.
If by that point means that we'll get started, resume the trial, Your Honor.
Yeah, we're going to continue. I'm not calling nothing.
I'm not going to participate in the trial without the Steele and
You don't have that luxury at this point in time, sir. You don't. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
without the court addressing the issue that we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
Respectfully, I will not.
Say again?
Respectfully, I will not. I cannot.
Sir, you have to.
He said, "I'm not going to participate."
Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No.
A violation of Mr. Williams' rights.
It's not, sir.
What happened is what we believe
Sir.
occurred is not.
That's not what. That's not what happened. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Bailiff's in position.
Respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then you made your. No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Mr. Steele, if you could stand up, put your hands behind your back. You have the right to remain silent. Anything you say or do can and will be used against you. Well, I guess it was used against you in court. You have the right to an attorney. You are an attorney. Anything you want to leave here with your co-counsel? Oh, white shirt for the mugshot. Bold choice. How about the tie? Yeah, lose the tie, too. Oh, hang on. Whoa. Now,
Your Honor, would the court afford me 1 moment to confer with counsel regarding the appropriate.
Anything else you want to?
This type of
Okay. All right.
Anything else you want to leave here? Maybe your shoes. Don't want those to get scuffed up. Those are some expensive leather shoes.
May I say one thing, Your Honor?
Yes, sir. You certainly may.
Parting words. This better be good.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Hey, enjoy the cell. You just missed lunch. Dinner's at 5.
We're going to be in recess for the next 5 minutes.
That's how you spend. That's how you spend a day in jail as an attorney. Okay, so we're going to skip ahead just a little bit because, oh my goodness, judge takes 5 minutes, right? He needs more than that to cool off, I think. He needs more than 5 minutes. Let's see. Let's see if we can skip to where he comes back. I cannot believe. Can you imagine any of this back and forth? The accusations, the jabs, the getting the last word in, the snarky remarks with Judge Beverly up there in Canton. You can't even look at somebody out of the corner of your eye without her saying, "Hey, overruled, objection sustained. We're going to strike that from the record." Yeah, this one is completely just off the rails. Let's see. I think we're back now. Break's over. I just want to see. I'm not seeing this far ahead. I want to see how the judge comes back, how he resets, see if he's like a Judge Carroll who can take a break after getting riled up and be a new man when he comes back out through the door. Who are we waiting for? Got to wait for all the attorneys to be seated. Mark my words, this trial will end in a mistrial. There's no way that, first of all, the jurors will die off of natural causes, of old age, before.
Is Mr. Adams in the hallway over there? Could you get him, please?
Mr. Adams, is he the guy who was saying I refuse to participate? Everyone's going to be old. The judge will have to retire by statute before this thing ends. I'm just saying this. There's no way I can see this case going through. It's going to end in a mistrial. It's too big. It's too clunky. There are too many moving parts. Just waiting for Mr. Adams. Co-counsel for Mr. Steele, who is in custody. Can you move that microphone so we can have a little ex parte here? He's like, don't shoot the messenger, but
He's refusing to come in.
What?
He's refusing to come in.
He's refusing to come in? He's refusing to come in. Now Mr. Williams doesn't have counsel present.
Can we?
Tell Mr. Adams to come in so I can put something on the record, please.
Tell Mr. Adams to come in so I can put something on the record, please. The judge is big mad. Oh, my goodness. You guys, if you're just joining us, I know Karen Reed Live just ended for the day. If you're just joining us, this Young Thug trial has gone off the rails. It's been off the rails for weeks, but today has reached a new level. Previously, last week, the state's witness, who agreed to be a state's witness, pled the fifth on the stand and was promptly arrested and taken to jail. Okay, you can't do that when you're a state's witness. The whole deal is that you're going to agree to testify and answer all the questions truthfully. It's been absolutely nuts. And today we've already got one lawyer in jail. A second one's refusing to come into the courtroom. Bailiffs are trying to convince Mr. Adams to come in. He's said he's refused to participate until he gets his way. Mr. Adams is present.
Just hang tight, sir.
Just hang tight. Hang tight. I do love my job. It does seem like something was done, though I don't know if it was illegal or not. As far as the rules go, it sounds like processes weren't followed to the best way possible. Sitting witness, sworn in witness, meeting ex parte with the judge and the prosecutors. It is on the record. It's preserved. It sounds like nothing would have happened. I believe it was recorded and typed. It sounds like they're talking about his plea deal, but should defense have been there? Defense says yes. How many months has this trial been going? This is day infinity in the Young Thug trial right now, and it's been forever. I do not remember. Does anyone know what day this is? Amber, can you count really quickly what day this is? Mr. Adams is present, fully aware that he might get to join co-counsel in custody in the lockup until 5 o'clock tonight, where they get to rethink their position. What the judge is saying, what the prosecutor is saying, is this could impact professionally their career, their licensing.
All right. Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams, and I don't doubt that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct that you continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that.
He's got
continue
one phone
to
call.
do that, but Mr. Steele put himself in this particular position in terms of all these. I'm not asking him for any other, or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mrs. Steele will not. I also will not. And I respect the support. I respect that the court has to do whatever it is appropriate, but I would ask that the court also respect my representation of Mr. Williams and standing for him when we believe that there's been a violation that affects his right to a fair trial, and we believe that is the position that we're in. And I would respectfully decline the court's order for me to continue forward.
Your Honor, may I?
I will respectfully decline the court's order.
Your Honor, there are two things at issue here, and one of them, Your Honor, is that.
Can I ask of the court how it is that the state has any position in this particular conversation between the court and myself?
Before we recessed, Ms. Love said that she was going to research this ethical issue because it is an ethical one. So just much like you could add to it, I'm asking the state if they wish to add to that as well, sir. Okay?
Thank you, Your Honor. Your Honor, we believe that there are two matters at issue here. One, obviously, is Mr. Williams' right to counsel of his choice during the trial of the case. We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion
She wants sanctions.
Punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that so far this issue alone has needlessly delayed the trial of the case, and we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session.
I think that would be appropriate under the circumstances. And
okay, pause. She is trying to slide Mr. Steele a get out of jail free card, but it's only during court. She's saying, I want him punished, okay? But if you punish him too much, then it actually takes away from Mr. Williams' rights, and then we do get into the mistrial area. And I think it would be best for all of us if you let him back out of jail for court and maybe just hold Mr. Steele in jail on the weekends. I don't know. I guess that's what our proposal is. Just weekend jail time for the prosecutor. But let the jailbird out and let's continue. Maybe he can put his tie back on, maybe his suit coat. I mean, he went in as a white knight. Did you see how he took his coat off? Your Honor, I go in with nothing but my white shirt, my cufflinks, and these dress slacks. And I am an innocent man of these charges. And you are the one who, oh my goodness, this is bizarre. Okay, continue, because it's not quite over yet.
Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So, yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish, the matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a party. It was a civil contempt matter, and the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing, the court compelled, and the state said, Your Honor, we're asking if the court, if they don't comply, that the court hold that person in contempt. That was a civil contempt matter. Nothing substantive was discussed. Everything was recorded, and the representations made, at least by persons who were present to the state, is that when questioned or queried about it, is that that person was told or asked whether things occurred, and that person relayed that no substantive communication took place during that meeting. So that is the second matter. And first and foremost, we just ask that the court, again, allow both counsels for Mr. Williams to be present when court is in session so that we don't delay these proceedings further.
All right. That's fair enough.
Thank you.
Okay.
Your Honor,
Mr. Sharp?
the ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the
Honor, can I just
Mr. Sharp. Here's the challenge. You got the information in a way that was not lawful to begin with. Sir, that doesn't alleviate the information or make it less valid or invalid. So, because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's great.
And like I said, if and when the case gets reviewed, an appellate court will make those decisions. But at this point,
my client is the aggrieved party. He was not present. If that violated his Sixth Amendment right to be present.
Okay, and that's your argument. Sir, that's your argument. That's your argument.
One other thing, Your Honor.
That's your argument.
All I'm asking for is some sunlight. Some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay. Well,
So
at this point,
we all know. Appellate only happens
like
if
I
you're found
said,
guilty.
I need to have a little bit more information in order for me to kind of make some other decisions in this case. I'm not saying that you may or may not get that information, but at this point, there was nothing that was improper about in the ex parte conversations. The court's more concerned about is the disclosure. So, and
I understand the court's concern, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
Okay. All right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because the Harvey rule's in effect. I understand everyone's opinion at this point in time.
And Judge, the only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present. His lawyer stated to Your Honor that he had spoken to his witness, his client, and he stated that the witness indicated that on Monday, he will also be saying that he will plead the fifth. And then, Your Honor, there was a 2-3 hour span this morning, and then he comes on and he says, I'm going to testify. That's why I believe, on behalf of Mr. Huey, that the transcript is important.
Okay. Thank you, sir.
Now,
all
sit
right.
down. Everyone sit down.
Let's get Mr. Steele out, please.
Oh,
We can tell him to put his tie back on.
Mr. Steele's coming out of jail. Cell box 7, can you let the lawyer out? Over.
And then we'll go ahead and get started. At that
Mr. Steele's going to come back, a changed man. A changed man. Let's give him a minute. I'm gonna fast forward just a little bit so we can get Mr. Steele out of jail. He's been languishing in custody all this time, and I mean I would give anything if he came back. His shirt's ripped. He's like, his hair is tousled up. He's like, yeah, had a run in at the mess hall. Man, this you cannot make this stuff up. And the funny thing is I've been ignoring this case for a long time because it is so soul-suckingly slow. Okay, it is. That's it. I mean, no one's attention span is long enough to sit here and say, yeah, let's sit through another day of Young Thug, right? But things like this happen every day in the Young Thug trial. They happen every day. We have, I think this is one we've already had I think a juror got put in jail as well at one point, or held in contempt, had to write a report. This is the craziest. The craziest. Suckingly is interesting, the word choice. Oh man.
All right, Mr. Steele. In the interest of your representation, continued representation of Mr. Williams,
please show us Mr. Steele. I want to see him get dressed.
Been brought to court suggestion that you be here until when we've in all open sessions of court and until we finish for the day. So I'm still going to hold you in contempt. You can purge that contempt by just telling me who it is that told you this information. That's all I need to know. But at the end of today, I'll ask you that question again today. We did not take up any business in your absence, other than Mr. Adams eloquently saying that he was not going to go forward without having you present with him. So, and him not wanting to divulge who the information came from either. So, with that, sir, we're going to go ahead and continue. All right.
Answer the question.
Yes, sir.
Did the court order the transcript that we can see it and have a hearing and call witnesses?
He's doubling down.
I'm not gonna order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. I don't believe at this point in time it is the court's understanding of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed. But I'm not at this point in time going to release any of the transcript in terms of what may be disclosed or that was said in Chambers ex parte at this point.
Well, I was told based upon information and belief that it would affect this witness's testimony in front of the jury, because I was told based upon information and belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about.
I don't know, Mr. Steele. I don't know. I mean, that's why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have a hearing with the court as a witness, with the DAs as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point, because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I mean, but that's beside the point at this point in time. We're not going to argue about that right now. I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said.
Yes.
I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How could something, I'm not trying to be obstruction, but how could something be attorney-client privilege if it happened before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't.
I mean, like I said, I don't know what was said to you. I don't.
I'm trying to get out.
That's improper at this point in time.
Why?
Because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you turn around and you say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was it is a material part of the trial.
It's not, well.
Has a right to be at, and I'd like to exercise.
It would be just like if you all in the past have had ex parte conversations with the court. And I won't say about for what. You and Mr. Adams and others. That is your right. And that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it where I'm kind of at a disadvantage at this point in time. So, because I didn't invite you into that particular proceeding, and I don't think you had the right to be there.
Well, all I know is what I told you, and there's more.
Okay, well.
There's a witness testifying who met with the court and the DAs. That doesn't concern us?
Your Honor,
meaning the defense?
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may be privy to or may have been disclosed to you, they're troubling. They are. That's why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you, but I do need to know who told you. So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then, I'll unfortunately have to look at and waiting to get that information. So you can let me know.
Did the court put this in an order?
In terms of what, sir?
I suppose contempt.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this. You will go into custody at 5 o'clock today or whenever we finish if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked you a question related to these particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important.
Important. It is important.
Okay. All right. So think about it. All right.
Can I just, last thing, going forward, is over objection, because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be a continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay?
And
all right.
On behalf of Mr. Stillwell, I'm going to review
our Brady demand for any Brady material
yes, sir.
that came out from any conversations with Mr. Copeland, between Mr. Copeland and the district
Yes, sir.
attorney's office this morning?
All right. Summon our jurors, please.
Okay. All right.
Yeah, bring him out, please.
All right. That is as far as we're going to go today. Because now it just continues. It keeps going. Oh my goodness. So apparently, I know it's what is it? It's 4:40 right now. What time is it? Hey Siri, what time is it in Fulton County, Georgia right now?
In Fulton County, Georgia, it's 16:40.
Okay, they're Eastern time as well. So in the next 20 minutes, this lawyer is going to find out if he spends the night at home or if he spends the night in jail. But I don't know. He's asked if the judge has put it in order. It's like, have you put it in writing, what you're ordering me to do, that you're going to hold me in contempt? And the judge, oh my goodness, spicy. All right, I just wanted to bring you that. I do apologize. I realize a lot of you, myself included, we love watching court live in real time. We will get back to that here very soon. Once the Karen Reed trial is over, we'll be watching court live. We're going to possibly pick up the Wade Wilson trial and speed watch that during the breaks, or maybe work late sometimes to get up to speed on that one. Which is probably going to be pretty interesting as well. And then I mentioned, can I just say, my wife is amazing. She just dropped a new video. If you're interested in homeschool at all, on her channel, Mrs. R.A., she just put a new video out. So go out there and click a like on it and say nice words to her, and that would make her day. Other than that, we also popped the Owen v. Eckerd paternity hearing. I have to be careful what I say. We published that over on the Top Mark Media. That's the live feed. If for those other content creators who are requesting that, that's available for use if you want to run commentary and things on that. And it's unmarked. It's logo free for you that way. Thank you. Mrs. R.A. says, that was sweet. Thank you. All right. That's it. That's it. I wanted to bring you some of the spiciness that happened today because of that. It is only it's only 4:50, but it's time for us to wrap things up again and say goodnight. I've got to say thank you to our amazing mods. I have pulled them around without warning over and over today, and they've just dealt with it. They've rolled with it and dealt with everything that came as a result. Not to mention all the work they do on the back end to help me out, whether it's just organizationally as I get going in the morning, or updates and heads up and warnings and news, breaking news documents. They're absolutely the most incredible people, and I am so grateful to have them supporting the channel. I could not do that without them. I could not do this without them. Thank you so much. You're all absolutely amazing. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe to go live again tomorrow morning. Tomorrow morning might be the Wade Wilson speed trial catch up tomorrow, because Karen Reed is not in court. But who told you about this? Don't know. I can't reveal my sources. I can't reveal my sources, Greeners. Come get me. Come get me. You guys have a good night. Be good to each other. We'll see you tomorrow.